Hi, I'm Susan O'Toole. I'm an attorney here at Beresford Booth, and I am presenting a webinar today on coercive control, which is a new aspect of domestic violence protection orders in the new statute recently passed and effective by the legislature. The new protection order statute is RCW 7.105, and most parts of the statute, as I said, were fully effective on July 1st, 2022. It's a very, very comprehensive overhaul of the protection order system in the state of Washington. It combines all types of protection orders in one place, and that is DVPOs, domestic violence protection orders, sexual assault protection orders, stalking protection orders, anti-harassment protection orders, and vulnerable adult protection orders. And so this one statute lays out the procedures for all of these types of protection orders. And basically what the statute does is it harmonizes the requirements for each type of protection order and makes it so that it's much, much easier for victims to access the protection order system in the hopes of diminishing all these types of issues that make protection orders necessary and making the system much more user-friendly. So there are some significant differences in the old statutes and the new statute. I'm not going to go into those in depth today. I may do a future webinar doing that. But just a few of those differences. In the old statute, each type of protection order had its own form. And if you got the wrong one, oftentimes you're out of luck. If I have been in court where a person's filing an anti-harassment protection order, and the court says, well, this is really a domestic violence situation because you are intimate partners with, or were intimate partners with the person who you claim is, sexually or is harassing you, and therefore you should have filed a DVPO. And so the court dismisses the petition, and you have to come back. In the new statute, there's one form, and there's actually a part of the statute that says that the court can't dismiss the petition simply because you checked the wrong box. So if you checked, it's a DVPO, and the court looks at it and says, well, actually, this should be an anti-harassment protection order. Well, the court can just deny your petition because you checked the wrong box. So that's a really big improvement for victims, that they don't have to go away and come back, and there doesn't have to be that time lag when they might become further victims and something much more serious might happen. In the old statutes, there was one statute for every kind of protection order, but service on the party that you were claiming harassed you or committed domestic violence against you, or whatever in each statute, service usually had to be in person. So you had to have somebody serve the person, find the person, and serve it on him. And it could be the police, law enforcement, it could be private service, but you had to find the person physically, generally, or someone had to find the person for service. In the new statute, there's kind of a recognition of technology and the way things have changed, and that there are other ways to give someone notice, which is what service is supposed to do. And so multiple types of service are allowed. Email service, internet service, you could serve by Facebook, personal service, law enforcement service are still also allowed, but there are also other types of service that make it easier for the victim to give notice to the person they say is perpetrated whatever acts have led to the protection order. So it makes it much more likely that you'll be able to go into court and say, I have served this person does have notice. And again, each statute and type of protection order had different requirements. And to some extent, that's still true, but all the requirements are now in one place, which makes it much easier to access the statute and see what is required for each type of protection order. And the new statute is designed to harmonize the protection orders to better protect victims, and to try and prevent some of the horrific things that we hear about in the news when victims are not protected. So I'm going to focus on one type of, one part of the domestic violence section of the new statute for the DVPO's, domestic violence protection orders. So in the definition of domestic violence in this new statute, domestic violence is defined as physical harm, bodily injury, assault, or the infliction of fear of physical harm, bodily injury or assault, semicolon, non-consensual sexual conduct or non-consensual sexual penetration, coercive control, unlawful harassment, or stalking of one intimate partner by another intimate partner, or all those same things perpetrated by one family member or household member on another family member or household member. So the first part is got to do with intimate partners, and the second part has to do if it's a household member. So brother, sister, father, mother, child, that sort of thing on the second one. And then intimate partners, people that you're in relationships in, that you're married to, that sort of thing. So as you saw, coercive control was part of the definition, and that's a new part of the definition of domestic violence. Coercive control was not included in the old statute as a form of domestic violence. And so what I'm going to talk about today is what coercive control means, and discuss some of the implications for that inclusion of the definition of coercive control means in the new statute. So coercive control is one of the new parts of the statute, and it's codified a concept known in domestic violence work for many years. There is a form of domestic violence that's been known wherein the perpetrator exerts control over the victim, and that can be without any form of physical violence. No hitting, no slapping, no punching, no shooting, no form of physical violence, just exerting control over the person's life. And I shouldn't say just, because this is a huge, huge part of domestic violence. It can be, as I say right here, it's a common domestic violence pattern. It can be anything from taking control of the finances, not allowing anyone to have any money, to be able to spend money, to be able to go anywhere, to be able to do anything, preventing the victim from having contact with their family and friends, isolating them, not allowing them to go out of the home, taking away their freedom. There's a wide range of behaviors that's been known for a long time in domestic violence work that is now under the definition of coercive control. And it's long past due, in my opinion, because it's one of the biggest ways that perpetrators of domestic violence take away the belief of victims that they can escape, or that they can get away, or that they have any sort of power over their own lives. It's essentially aimed at disempowering the victim completely so they can't get away from the domestic violence. And so what I'm going to do now is I'm going to go through the definition of coercive control. And I'm simply going to read from the statute because I think it's well written, and I think it gives you a very good idea of the vast breadth of this change in the definition of domestic violence and how many more victims it's going to protect. So in the definitions section of the new statute, which is RCW 7.105.010, coercive control is defined. And it starts out by saying coercive control means a pattern of behavior that is used to cause another to suffer physical, emotional, or psychological harm, and in purpose or effect unreasonably interferes with a person's free will and personal liberty. In determining whether the interference is unreasonable, the court shall consider the context and impact of the pattern of behavior from the perspective of a similarly situated person. And so that means that when you go into court, if you're trying to argue that coercive control has been part of or all of the domestic violence against you, the court is going to look at whether the interference is unreasonable and say, is this something that someone else in this position would think is unreasonable? And then the definition goes on to say, examples of coercive control include, but are not limited to, engaging in any of the following: intimidation or controlling or compelling conduct by A, damaging, destroying, or threatening to damage or destroy, or forcing the other party to relinquish goods, property, or items of special value. So I've had cases where the opposing party, one of the things that they do is they took everything from my client and they refused to return those things. And it was part of a pattern of coercive control, taking things that matter from you. B, using technology to threaten, humiliate, harass, stalk, intimidate, exert undue influence over, or abuse the other party, including by engaging in cyber stalking, monitoring, surveillance, impersonation, manipulation of electronic media, or distribution of or threats to distribute actual or fabricated intimate images. So, you know, threatening to put people's intimate pictures on Facebook, any sort of electronic use of technology to do any of those things: threaten, humiliate, harass, stalk, intimidate, or exert undue influence over or abuse the other party. C, carrying, exhibiting, displaying, drawing, or threatening to use any firearm or any other weapon apparently capable of producing bodily harm in a manner, under circumstances, and at a time and place that either manifests an intent to intimidate the other party or that warrants alarm by the other party for their safety or the safety of other persons. D, driving recklessly with the other party or minor children in the vehicle. I've had clients who have been in the car where the perpetrator of domestic violence is speeding around in a manner that's very unsafe to try and get them to do what that person wants them to do. I had a client where there was a child in the car, and to stop the person from driving like this, my client gave in, and that is under this definition. And then E, communicating directly or indirectly the intent to, 1, harm the other party's children, family members, friends, or pets, including by use of physical forms of violence. 2, harm the other person's career. 3, attempt suicide or other acts of self-harm. Or 4, contact local or federal agencies based on actual or suspected immigration status. So I've had clients where the other party, the perpetrator of the domestic violence, has said, if you go to the cops, if you try and stop me from doing what I'm doing, I'm going to report your immigration status. I'm going to tell the federal agencies that you are here illegally, or that you are here beyond the time of your green card. Harm the other person's career. Any sort of threats to harm their career could fall under coercive control. F, exerting control over the other party's identity documents. So if someone withholds your identity documents so that you don't have the necessary documentation to present as to your identity or immigration status. That's covered under this statute. G, making or threatening to make private information public, including the other party's sexual orientation or gender identity, medical or behavioral health information, or other confidential information that jeopardizes safety. So any kind of private information that is covered under here that you threaten to make public against the victim's wishes, again, another form of coercive control. And then H, engaging in sexual or reproductive coercion. And that one I think is pretty self-explanatory. And then 2, causing dependence, confinement, or isolation of the other party from friends, relatives, or other sources of support, including schooling and employment, or subjecting the other party to physical confinement or restraint. And this is part of a very, very common pattern, as I was saying before. Isolation, preventing you from having anyone around you or anyone to talk to that can help you, preventing you from going places where you might find a job and have some sort of independence, go to school, that sort of thing. It's a very common pattern in domestic violence. And once again, it's codified in this new statute. 3, depriving the other party of basic necessities or committing other forms of financial exploitation. So say that the person is preventing you from being able to bathe, if they're preventing you from having money to be able to buy food that is good for you. I mean, basic necessities is, when someone deprives you of that, again, that now falls under the definition of domestic violence and the definition of coercive control. Controlling, exerting undue influence over, interfering with, regulating, or monitoring the other party's movements, communications, daily behaviors, finances, economic resources, or employment, including but not limited to interference with or attempting to limit access to services for children of the other party, such as health care, medication, child care, or school-based extracurricular activities. And this, again, when there's children involved, is a very common pattern for the perpetrator to use those children to control the other party, not allow them to take the children to the doctor unless they do what they're told. Monitoring your movements with the children or monitoring your movements alone so that you can't go anywhere without them knowing about it. Communications. I mean, nowadays, if you are a perpetrator who wants to control another person, you can go online and see what their internet traffic is like, see what websites they go to, see who it is, what it is they're researching. If they're looking for an attorney online, you can look and you can see that. If you, if you go into somebody's internet usage, preventing them from having a phone, looking at their text messages, tracking their text messages, those types of things. Again, coercive control, domestic violence. And 5, engaging in vexatious litigation or abusive litigation as defined in RCW 26.51.020 against the other party to harass, coerce, or control the other party, to diminish or exhaust the other party's financial resources, or to compromise the other party's employment or housing. I've had clients who the other party has filed motion after motion after motion until they were financially unable to keep fighting, whether it was for their children or for a home to live in. And so it was litigation specifically designed to prevent them from being able to have financial resources and to financially break them. And again, you would have to provide proof to the court. You would have to show the court how it qualifies. And abusive litigation is defined in RCW 26.51.020. You'd have to, if you were going to be asserting that, you would have to provide proof and it would have to meet that definition. But here, there's the possibility that domestic violence can include these types of actions if you provide proof and you convince the court of that. And 6, engaging in psychological aggression, including inflicting fear, humiliating, degrading, or punishing the other party. And psychological aggression is a huge part of domestic violence, making the other party believe they can never escape, making the other party believe that they deserve this. All sorts of very, very common patterns in domestic violence. So that's the entire definition of coercive control in domestic violence production or actions. And one thing, the legislature goes on to say that coercive control does not include protective actions taken by a party in good faith for the legitimate and lawful purpose of protecting themselves or their children from the risk of harm posed by the other party. Which is, that's a really important thing to say. If you're taking these actions to try and keep yourself and children, your children or other children safe from the other party, it gives you a defense if you are charged. If the other party tries to make it seem like you're the one that commits coercive control, domestic violence, you can present information to the court that says, this is why I did what I did. So in terms of the implications of the expanded definition of domestic violence to include coercive control, there's a lot of them. And I think I covered some of them just in reading the definition, because it really is a very, very expanded definition in terms of domestic violence. So one of the implications, it vastly expands the types of domestic violence protection order petitions that can be brought to protect victims from many more kinds of domestic violence. Under the old statute, you tried to argue that a lot of things that are delineated clearly in the new statute are domestic violence. And those of us who have done work with domestic violence for a long time, and the judges, we all knew that that was part of the domestic violence. But making your petition fit under the statute and the definitions of the statute with domestic violence, sometimes it was difficult to try and convince the court that this was really domestic violence under the statute, the old statute. And now with this expanded definition, it's codified. It's codified in the statute. The court has to consider it. And second, it is enough to have financial coercive control or attempts to harm someone's career, or communicating the intent to contact local or federal agencies based on immigration status. It's enough to threaten to make information public about someone's gender identity or committing financial exploitation. This statute now says that it's enough to have any of those or any of the other aspects of coercive control to prove domestic violence. You still have to prove it happened. You still have to prove it's real. But now you have a statute that says these things are included as domestic violence. And the last thing I want to say is that attorneys can help. Attorneys can help with this. And if you think you're a victim of coercive control, domestic violence, please reach out to me or to another family law attorney, attorneys that do domestic violence. This statute says, this new statute says many, many more things that have been recognized in the literature and by experts in domestic violence, those of us working in domestic violence for years. Many, many more things are now in the statute. The court has to consider them. You can ask for help. Attorneys can help you craft your petition, craft your declaration, and present your evidence so that if you are a victim of these types of things, you can get help. So again, I'm Susan O'Toole at Beresford Booth. There's my email address. There's my phone number. And if you don't call me, if you're a victim of domestic violence, please reach out, call somebody, contact somebody. Thank you so much.